applications, how do we apply? Application must be made in writing, but it can be done by email. Why do we accept? We do not accept applications orally or by telephone, mainly for linguistic questions. Applications can be made in any of the now 23 official languages. So it could lead to misunderstandings if the applications could be made orally by telephone. So in Irish,
Greek.
Yes, we have received incident. Well, it happens once a year that we receive an application in Greek or in Irish or in Lithuanian or one of the less spoken languages.
The more exotic language.
So most of the applications are received by email. Either receive an email, we have a mailbox on the internet where we see the applications, or there is an electronic form on the internet associated with the public register where people can make their applications. There are hardly any formalities the only thing we request is that the application is sufficiently precise so in order to enable the services to identify concrete documents. If an application has not been granted or not fully granted, then the applicant has the right to request a review to the institution. And it is an obligatory step before going to the court or making a complaint to the Ombudsman. The applicant must exhaust the internal remedies with the institution. So that's called a confirmatory application, which is the kind of administrative appeal. And then the case is reviewed, and that is precisely, that has been my job for the last years. I'm in charge of a team that reviews requests for access that have been rejected by a department in the Commission, and we take a second look and we prepare a decision taken by the Secretariat-General, who takes a decision on behalf of the Commission. And that decision taken by the Secretary-General is the final position of the Commission that can then be challenged in court or lead to a complaint to the European Ombudsman. So we now come to the some details, the time limits. I said if the application is not being handled within the time limits, this is considered an implicit rejection. So we have to handle them within 15 working days, with one possible extension to 30 working days in total. The same applies at the second level for the confirmatory applications. In principle, we can charge the copying pages. We can charge 10 euro cent per page, exceeding 20 pages, and carriage cost, but in practice we never charge. In theory we may do it, we do never do it. So in fact, requests for access are normally completely free of charge. And then, as I said, when the institution has not replied within the time limits or rejected or partly rejected, then there are two ways for an applicant to seek remedies, either a complaint to the Ombudsman or to the court. The applicant has to choose one way or the other, because the Ombudsman cannot handle a complaint if the substance of the complaint is at the same time pending before a court. So the two systems are exclusive. And since there are time limits, if you want to go to court, you have to do it within 70 days. It's 60 days, 2 months, plus 10 days on account of distance, which now has been uniform. It's now it's for everybody. Even from Brussels to Luxembourg, it's 10 days. Somebody, when they made a joke, say you must be going on foot to Luxembourg. But so within 2 months you have to make the complaint. The Ombudsman is 2 years, if I'm not mistaken. But by the time that you have a judgment of the court, it takes at least 2 years. So it is more or less exclusive. There are exceptional cases where somebody made a complaint to the Ombudsman and then went to court. However, if somebody wants to have a court decision, even if he's not satisfied with the outcome of a complaint, he can make the same application again, because nothing prevents an applicant from making the same application, requesting the same documents that have been refused, and then the institution has to look at it again and to take a new decision, which can be the same or which can be different. So, some typical applications which are typical for the Commission, because as Bart Driessen has mentioned, there is legislation on the one hand, but the Commission is also a body that has a lot of law enforcement tasks. For example, in competition law, anti-dumping, and in infringements of member states. These are areas which are favourite areas for requests for access to documents. And in fact, the confirmatory applications that I handle are normally not related to the legislative activities of the Commission, because where there is more transparency, but basically it's about the enforcement activities. It is a request for access to exchange between the Commission and the Member State on an infringement case, or access to a file in a state aid or merger case, or an antitrust case. And then we have also, these are mainly applications made by law firms, And then we have another group of clients, which are the NGOs, and they rather would make very wide requests for access to any information related to the relations between, for example, a commissioner in a certain area of policy and the industry. For example, relations between a commissioner in charge of industry and the chemical industry on environmental issues or on CO2 emissions. Or now, a favorite subject now is biofuels and tar sands. So these are typical requests for access made by NGOs. We started to give you an idea of the volume, we started in 2001 with 500 requests a year, and we ended last year with 6,000 requests a year. So it's done, the number of initial requests has risen from 500 to 6,000. The confirmatory applications remain stable around 200 a year. So in fact, from the 6,000 initial applications, around 80% are granted at the first stage. From the remaining 20%, we receive 200 appeals. And from these appeals, then, I can say that in 1 out of 2 confirmed applications, we tend to grant wider access than what has been given at the initial stage by the relevant department. Either we grant partial access where access has been fully refused, or when partial access has been granted, we grant we grant access to more documents. Sometimes also the situation has changed in between, which leads to more transparency. At the end of the road, we have around 15 to 20 complaints on such decisions a year to the Ombudsman, and around 10 to 12 cases in the court. Who applies for access to documents? 1/3 is done by students and researchers, so the academic world. About 20% by lobbyists, and I must say in the lobbyist category we also include NGOs. With respect, but I mean we have a broad category of interest groups, which can be also NGOs and interest. The law firms account for about 10-11% of the requests, and then we have around 35%, 1/3 also citizens or undefined, because we receive a lot of requests by email where we don't know exactly what the profile of the person is. Okay, just a few words about the review of the regulation that was announced. So, 2 minutes.
Please.
Yes.
You're dangerously close to 20 minutes now.
Yeah. Why review the regulation? In 2004, the Commission published a report, an evaluation and assessment of how the regulation worked, and came to a positive conclusion that it worked well. It has led to few problems. It only is quite labor intensive, as Bart has already said, because if we have to look at each and every document and we receive very bulky applications, it's a lot of work to go through all these documents. But in terms of the assessment whether or not the document should be disclosed, we had hardly any. We were never forced to disclose a document that really should not have been disclosed because it would have been harmful. So, why review the regulation? Basically, it's because the European Parliament wanted this. The European Parliament started in 2004 to put some pressure on the Commission to review the regulation. And when President Barroso took office in the first Barroso Commission at the end of 2004, the Parliament made him make a promise that he would start the review process during his mandate. So, in 2007, the Commission published a green paper consulting the civil society, and we received a number of reactions to that. About 80 and something reactions we received, some from member states, from public administration, some from the industry, from the NGOs, and some from individual citizens. A year later, in April 2008, the Commission made a proposal for reviewing the regulation, and the proposal is quite, it's not revolutionary in the sense that the Commission wanted to keep the existing system more or less as it was, but to add a few things to make it a bit more precise, because the regulation has some grey areas, and the Commission tried to address some of these grey areas, also drawing lessons from the case law, trying to be a bit more specific in certain areas, take into account the case law. Basically, it's what the Commission tried to do is to have a slightly more precise definition of what is a document, and that has been criticized, but we can come back to that maybe if there are questions on it. And the Commission also tried to be a bit more precise in the relation between personal data protection and transparency, because that had been a difficult issue in practice. and also to be more specific, to draw lessons from the case law regarding access to member state documents. This proposal has been tabled on April 2008 and is still on the table because the Parliament has not yet formally voted its position at first reading. The Parliament has adopted a report in March 2009 with about 90 amendments to the Commission's proposal, 60 of which are considered by the Council and the Commission to be out of scope because they touch upon parts of the regulation which the Commission did not propose to amend. And here we come into a kind of institutional debate. In principle, the legislator, Council and Parliament, are bound by the proposal of the Commission. So if the Commission proposes to change some articles and not others, the legislator can only act in fact on the articles that have been touched. So we consider that 2/3 of these amendments are in fact out of scope. Of course, politically, you can always negotiate and find an agreement, but strictly, legally speaking, these amendments are out of scope. What the Parliament wants to do is to reduce some of the exceptions to the right of access, including taking away the exception which protects the decision-making process, that they want to scrap it completely. The Parliament also want to delete, to make exceptions inapplicable in the legislative process, because as Bart has said, there is more transparency in legislation, and the court, in fact, has come to this idea of more transparency in legislation. So the Parliament now wants to completely make the exceptions inapplicable to legislation, to leave them only for non-legislative documents, and also to reduce the consultation of third parties and to reduce also the influence of member states on the disclosure of their documents. In addition, among the less admissible amendments are amendments concerning the introduction in the regulation of classification rules on secrecy, which are a different issue, and also to merge the rules on access to documents, the public access rules, with the rules on historical archives, which is also not exactly the best thing to do. So for the moment, we are still waiting for the Parliament to vote on a report. We are still at first reading, and there is no date. There has been a debate in January in the Civil Liberties Committee, which is the lead committee in Parliament on this subject, but there was no formal document submitted. There was only an exchange of views, so no vote for the moment. So it's difficult for me to say where we are going. It's a long process. And in the meantime, we are not in full compliance with the Lisbon Treaty, because Lisbon expands to all institutions. In practice, more or less, we do it, but we have not enacted this in the legislation. Thank you.